Hi, I'm Justin Timmer. I'm a family lawyer here at Conditsis Lawyers, and we're speaking with Julie Carney today from JK Resolutions. Hi Julie, thanks for joining us.
Pleasure, Justin.
Today we want to have a talk about arbitration and in particular why solicitors should be advising their clients about arbitration, what it is and how it all works. But before we dive down into that a little deeper, for those who don't know you, perhaps you can, by way of introduction, give us a little bit of information about your resume, which is pretty impressive.
Yeah, thank you. I have been involved in family law for over 25 years. So I spent 10 years as a solicitor like yourself, became accredited in family law. I then went over to the court and was a registrar with the court, with the family court and the Federal Circuit Court for another 10 years. And in that role, I was sitting on the bench making procedural decisions. I was in chambers running conciliation conferences, which is another form of mediation. I was also at that time asked to become a published author with LexisNexis, and I'm still in that role. So there's a number of different national legislation documents that I prepare for them. And then about 5.5 years ago, I went to the bar. So I became a barrister running advocacy for parties in trials and interim hearings, and I also became appointed as a private arbitrator. So that's, I guess, a really emerging area of practice for lawyers, and I'm really pleased to be given the opportunity to talk about it today.
All right. And you left the bar not that long ago, in fact, was it?
No. Well, I'm still practicing. I still have my barrister's certificate,
Sure.
But I've been just really focusing on mediation and arbitration probably for the last 12 months or so.
Okay. And so JK Resolutions came about 12 months ago.
Yeah.
And that's you offer obviously all sorts of ADR services.
Yeah.
But for today's purpose, we'll dig down into arbitration.
Terrific.
So the first question is, why should solicitors be advising their clients about arbitration? Specifically, the Family Law Act, I think Section 12E provides an obligation for practitioners to advise their clients about arbitration and other prescribed matters under Section 12B, which specifically refers to arbitration. And I think anybody who's appeared before His Honour Harmon's court in a property-only matter where there's no significant family violence allegations or anything of that nature may have been witness to or the subject of a lecture from His Honour about not complying with professional obligations. I can recount one experience where I was sitting in the back waiting for my turn, and His Honour asked a solicitor, "What's your client's view about arbitration?" And the response was, "I don't have those instructions." And I can tell you he got a serve and a lecture for not complying with his obligations. So I think that's probably the biggest and most obvious reason that you would be talking to your clients about it. But of course, there's a lot of benefits that arbitration could offer in a property-only matter or a financial matter. So I think what we'd like to do today is to assist other practitioners out there who are complying with their obligations, of course, and giving this advice. The sort of advice that they can give their clients to essentially sell them on the benefits of arbitration. So we'll start with what sort of matters can go to arbitration.
Okay, so taking one step back from that, there's two different types of arbitration. There's private arbitration and then there's court-ordered arbitration. So in both of those, you can deal with property matters and spouse maintenance matters, just for example, for married couples and de facto couples. And in terms of the private arbitration, you can actually go one step forward. So this is arbitration that's not even in court. Mm-hmm. Parties they might have gone to a private mediation, didn't settle, but realised that weighing up the costs of going on to litigate versus let's just sort it out now means that they'll agree to go into private arbitration. So if you do that, there's a number of other areas of law that you can have the arbitrator consider, which is binding financial agreements and superannuation splitting orders, and also Section 106A orders about getting someone to sign documents because someone hasn't been compliant. So they are extra things that can be done through private arbitration that can't be done when you go to court. Mm-hmm. And so to support that, the court will actually, and there's rules around this, but the court will actually issue subpoenas so that even though you're not in court, you still get the benefit of some of that coercive powers of the court, asking for bank records, for example, or taxation records of third parties that parties can't easily get themselves, but they need to run their private arbitration.
All right. Oh, well, thank you for that. So, knowing that probably covers most things that in a property only or a financial cause, what are some of the other benefits that we could recommend to our clients? I understand that it's a lot quicker to get through the whole process. So from originally agreeing or to go through an arbitration until the award being handed down. What's the sort of time frame or what should people expect?
So time frame's really driven by how ready parties are. So if you've done all your valuations so that you've really got a balance sheet, and for most people they've achieved that either through, they've gone through a court process conciliation, or if they've done private mediation, they've been forced into, let's talk about what we're all worth. So if you've got all those issues resolved, then really the duration of the arbitration depends on the availability of your arbitrator and also of counsel, because counsel normally run the arbitration hearing. So generally probably 5, maybe 6 months from the time that you appoint the arbitrator, because there's a preliminary hearing that they'll have, and that should be with lawyers and counsel, just to talk about the mechanics of how the hearing will operate. Then you've got your hearing, which again is really subject to the whims of the diaries involved. And then, generally speaking, the arbitration agreements allow 28 days from date of hearing until the award must be published.
Well, that's certainly quicker than the several months, if not more than that, waiting a decision from.
That's right.
The judge.
And you have, and that's the benefit really of arbitration, besides the timeliness factor, is that parties take control of the process. So it's a contract between you and the arbitrator. So you can say, arbitrator, I would like this decision handed down in 14 days. And the arbitrator can either say, yes, I can do that, or generally speaking, that the norm is usually 28 days. The parties can agree, we don't want any rules of evidence. We want this to be very informal, or we want all the rules of evidence. We don't want this to be a formal hearing where people are cross-examined. We're happy for you to do it on the papers. Even the location is up to the parties. Everything is very much on the table in terms of how they want the arbitration to run. So they get a lot of control over process. One of the other factors that is of benefit is you choose the arbitrator. So you can pick an arbitrator because there's a whole raft of experienced arbitrators out there. So you've got people who are retired judges, senior barristers, you've got lawyers who do it. So people can really kind of suss out the field and work out who's going to be the best fit for the issues in their case.
I think that's a really important point, because every matter is different, and so I think it's great that you could, knowing that we have to agree to go to arbitration and we have to agree on which arbitrator we're going to appoint. If we've got a complex property matter and we've got trading trusts and family trusts and corporate entities and self-managed super funds and all that that fun stuff, then you can really go through the CV of an arbitrator and find somebody that maybe has a bit of corporate law experience, and make sure that when you get to your hearing, which you can control, as you've said, that information or the opinion that's come from any expert is not going to be a bit lost on your decision maker. So,
no. And of course, one of the other issues about the arbitration is it's very private, and you get heard on the day. So often now, and it's just a tragedy of the court process and the lack of resourcing that's available, that judges will have directions hearings at 9:30, and then you won't be the only matter listed at 10 o'clock. So lawyers have to then go through this process of explaining why this process is going to work for their clients, whereas arbitration takes all of that away. It's a very private space. There's nobody coming into the back of the courtroom to see what's going on. It's completely closed to the public, and you will run with a judicial officer who's actually focused on just your case, not what's going on around them.
Yeah, I think that's particularly the case in the Federal Circuit Court, where we're frequently overlisted. And I think that there's probably some benefits in the costs that a party might incur in getting through a final hearing as well, because of the guaranteed hearing date. So when you arrive at your arbitration, we know we're going to run, we're not going to be interrupted. In terms of cost, because that's a common objection I get. So if I'm giving a client advice about the benefits of arbitration, sometimes we see resistance because there is a cost. I mean, there's a fee that is paid to the arbitrator. And it's hard to get a client sometimes focused on the bigger picture. And sometimes when they're faced with an immediate cost of whatever the fee might be, that seems expensive. But what they're not thinking about is if you, particularly if you're in the Federal Circuit Court and you're a property only matter, if you're overlisted in the 3 parenting matters on that day, certainly they're going to take priority, and you might not be reached. And so then of course the matter goes over to a new call over for another date at some point in the future. And the time can be anywhere between 12 and 24 or even longer in some cases, months. So I think the cost of running a file for your client, even if it's $500 a month or $1,000 a month, and you times that by 24, it's $24,000 already. Then you get your hearing date, which you're not reached, but you've prepared your trial affidavit, you get counsel, you get up there, you've got your outline ready, you're all ready for cross, and the judge says, I'm really, really sorry, I can't reach you today. But that's all a cost as well. So there's probably another, $10,000, $20,000 in preparation, and it gets wasted because we get adjourned.
Yeah.
So,
and not to mention all the interlocutory problems that can arise, which may mean that you have to lodge an application with the court for an interim decision to be made in the meantime.
yeah.
And just that disappointment that lawyers have to manage with clients who are saying, well, this just isn't fair. Why can't they hear my matter? I've spent all this money. Why can't you make that happen?
Yeah. And another frustration we see is you go to your final hearing, and I think it's a common misconception amongst most clients that you're going to have your final hearing and the judge will be in a position to make a decision that day. That's certainly not how it happens.
No.
That's just not the case, and it would be unreasonable for us to put that sort of pressure on any judge presiding over our matters. But I've seen delays of up to 9 months in recent times. So if you've got a property matter, particularly if you've dealt with the sale of an asset and you've got a trust account that's full of cash, but everyone's sitting around waiting for their money, that's extraordinarily frustrating for clients.
Not to mention the solicitor's cash flow.
Yeah, well, that's right.
Because
so,
if you're waiting for your fees to be paid.
Yeah, if you've got a pay at the end matter,
yeah.
If you've taken on the client as a pay at the end, it's quite common for people to be asset rich and cash poor, as we know. So that's right. I mean, if you can get a decision within 28 days of that hearing, I think that's a win-win for both law firms and practitioners and clients alike.
And then, of course, once you have that award, it's a matter for parties, but a lot of parties will then register the award with the court. So we've now got His Honour Justice Wilson, who's running the National Arbitration List, very, very proactive. So he'll get an application to lodge to register the award, and they'll actually reach out, Chambers will reach out to the other party and say, we've got this application, if you want us to deal with it by consent more quickly than the 28 days, because you've got 28 days to decide if you're going to object to the registration, they are actually reaching out to parties because they can see the real merits in showing to lawyers and clients alike, this is a process we are supporting as a judiciary.
We've probably just touched on another concern that we hear from clients, and that is that there might be a perception that somehow a judge is the best qualified person for the job. And I know we've already touched on briefly that you can pick your arbitrator. So I think anybody that's going to agree to go through an arbitration must necessarily be satisfied that the arbitrator's got the credentials to handle their case. You get to choose. Whereas if you're in the courts list, you don't get to pick your judge. No. you could end up before anybody. I'm not here to criticise any judges about their ability, certainly not. But I think it's important for people to understand that you're going to be choosing the arbitrator, and you can therefore really be satisfied that they've got the ability to be able to do it. But I think notwithstanding all of that, we still hear some concerns raised by clients that they think that the judge is the one that's in the best position. I think you mentioned earlier some of the arbitrators that are out there are retired judges.
They are.
And so, in some respects, arguably, they've got more experience than others. So I think it's an interesting objection from clients to not consider arbitration on the basis of experience. And I can think of a few judicial officers who well and truly support arbitration, and I think if it's good enough for members of the bench, even the Chief Justice, I think you mentioned, is
Absolutely.
a massive supporter. So I think if it's good enough for the people who make these decisions anyway, then why not for clients?
Look, I think, without speaking for the court, but certainly the message we're getting as practitioners who work in the court is that if there's a way to get parenting cases in particular through the system more quickly by allowing property cases the option to choose their own judge, choose their own controlling situation for how they want to run their hearing, we'll support it.
Yeah.
So, and the National Arbitration List is a really positive indication of that support. And I know, just the way His Honour's running the list, Justice Wilson's doing a terrific job.
Yeah. It makes sense. You talked about it being private as well, and there might be, I can think of a couple of matters where there might be some particular issues, remembering that a matter might be referred by a judge to the ATO for non-compliance with the self-managed super fund or for other questionable transactions. So if you've got a property-only matter and you've got some of those live issues, well, I think you'd be doing your client a disservice not to suggest arbitration as an option if you've been through mediation, we can't reach an agreement, because it is private. So
completely confidential.
Right. All right. So that all sounds really, really positive, but the reality is we're not seeing a lot of people engaging in arbitration.
No.
I'm wondering if that's just come down to these misconceptions that the judge is the better decision maker, or if it's anything else. But isn't it the case that the stats for the awards that are being delivered are standing up?
They are. Yes. I mean, I can only go on, I guess, an informal examination of the various databases online, but I can't see any decisions where they've been actually challenged in the sense of that decision has been knocked down on review. So there have been over 100 of them registered, and remembering not everyone registers their arbitration award. A lot of people are happy with the award, happy to do it informally. It ticks off all the issues in terms of stamp duty and CGT. All of that is resolved within the award, so that the statutory bodies are also acknowledging this is a good system. But for some people, they do want to get it registered. But in terms of registration, over 100, I think there's been maybe 10 or 11 that have actually had challenges that I've seen, because obviously they don't report every decision in the Federal Circuit Court, but I haven't seen any that have been upheld. So there's been one where it was a procedural hearing where the judge was concerned that there hadn't been procedural fairness given by the arbitrator about some of the directions that were made, but they didn't take it out of the list. They just said, go back and see the arbitrator and do that again.
Okay. If it's also positive with all of these benefits, it doesn't make much sense to me why more people aren't engaging in it. So if there's any practitioner out there, you've got a client that's got a property matter only or a financial cause, if they want any more information, are you happy for them to pick up the phone and ring you and have a chat to you?
Sure, absolutely.
All right, we'll make sure that we give your contact details, put a link to that in this video.
Thank you. And if I could just say this, I think it's terrific that Conditsis lawyers are actually supporting this, because it is an emerging area of law. A few years ago it was never heard of in Sydney, and now it's really booming because people can just see the benefits of moving on with their lives, particularly in a property market that has ebbs and flows.
Yeah, that's right.
There's this risk that if you take too long, things are going to change and you can't claw back those years and those values. So I think it's terrific that you're supporting it. And the other place that if people want more information about arbitration is AFLAM, which is the organisation that actually accredits all of us. So they have a wonderful website that provides information.
Well, that's very kind words from you, so thank you for that. But I think you've, just to sign off, as it were, I think you've hit on another issue. Anybody who works in family law, probably on the Central Coast and the Hunter region, knows there's a boom that's happened since October 2020. And so, like you've said, sometimes you can't claw back if it's market movement. So you've got people who had intended to buy the other party out and pay a settlement sum, that becomes a further and further distant reality the more the positive movement continues. So I think, again, you're probably doing your client a disservice, and I'm sure, I can't speak for Harmer, but I'm sure he would agree that you're probably not complying with your professional obligations if you don't provide the advice about all ADR, but in particular also arbitration
Absolutely.
as a viable option. All right, well, thank you very much for joining us.
Pleasure.